This is St. Louis on the Air from St. Louis Public Radio. I'm Elaine Cha. In 2001, a Missouri court case put the very idea of innocence on trial. On one side was Joseph Amrine. Amrine was facing the death penalty for a fatal stabbing in prison, a crime he insisted he did not commit. Evidence backed him up. Witnesses recanted he had already spent more than 10 years in prison. But when his case for innocence came before the Missouri Supreme Court, a remarkable thing happened. The Office of Missouri's Attorney General opposed Amrine. A state's attorney argued that new evidence showing Amrine was innocent did not matter because Amrine had already been found guilty. This puzzled one of the justices, Laura Denver Stith. She posed a question for the state's attorney. Are you suggesting that even if we find that Mr. Amrine is actually innocent, he should be executed? The state's attorney responded, that is correct. Joseph Amrine would eventually be exonerated and freed from prison. But this fundamental question, does innocence matter in the legal system, has not been resolved. More than 20 years after the Amrine decision shaped Missouri's definition of, quote, actual innocence, Missourians are still fighting over what it means in court. Last summer, a St. Louis judge vacated the 1991 murder conviction of Christopher Dunn, who was freed after more than 30 years. As in Amrine's case, key witnesses in Dunn's case recanted, which showed that Dunn should have never been sent to prison in the first place. Despite that, the Missouri Attorney General fought to keep him there, and even after Dunn's release last July, Attorney General Andrew Bailey, as recently as last month, is still appealing to the Missouri Supreme Court to oppose Dunn's case for innocence.
This is Missouri. Innocence has never been enough. Never since the beginning of times. How can you sit there and say that you are defending the law when you're preventing the law from even existing?
Dunn spoke yesterday with St. Louis on the Air producer Danny Wysentowski and said that waiting on the Missouri Supreme Court to decide his fate was like living under a cloud. He criticized Missouri's Attorney General and acknowledged the possibility he could be sent back to prison.
Right now, I'm just sitting here waiting to see if the Missouri Supreme Court is going to rule with the consciousness of the law.
That was Chris Dunn speaking about the attack on his case for innocence by the Missouri Attorney General. And to talk about what innocence means in Missouri and how new legislation could change it, I'm joined by Kenya Brumfield-Young. She's a professor and criminologist at St. Louis University. Kenya, welcome to the show.
Thank you for having me.
And we're also joined by Charlie Weiss, attorney with Bryan Cave Leighton Paisner. Charlie's legal work has led to the release of 5 people, all found innocent after spending years in prison for crimes they did not commit. He was also part of the legal team for the St. Louis Circuit Attorney that successfully argued for the innocence of Lamar Johnson in 2022. Charlie, welcome to you as well.
Good morning. Thank you for having us.
So just to start this off, I'd like to hear from both of you about this notion of innocence, which seems on its face very simple to define. Why is this so complicated, Charlie, in Missouri's legal system?
That's a good question, and it shouldn't be complicated, and there shouldn't be a dispute about it. Our experience, we first got into the innocence work in 2006. We investigated Josh Keyser's case, found that he was actually innocent. We assembled all of the evidence we had. We sat down with the Missouri Attorney General's office. We laid it all out to them in about a 2-hour meeting with them. And at the end, they looked up and said, he may well be innocent, Charlie, but we're going to automatically oppose all of these innocent cases, so file your case. And that hasn't changed 20 years later.
Mm-hmm. Kenya, how did you become interested in this subject, innocence in Missouri?
Well, I became interested in innocence in Missouri because doing some research on some previous cases, I noticed that because of two standing precedents, which was State versus Amrine and Lincoln versus Cassidy, that we had kind of weaved out or carved out the system that only allowed claims of freestanding innocence for those who were currently on death row and for people who were not. And I thought that was an inequitable application of the law, and so it kind of thrust me, so to speak, into looking into some of these cases and having a better understanding of the way we navigate these claims in Missouri.
Mm-hmm. So if we think about what the current status is and who is even allowed to make a claim for innocence, Charlie, who's qualified, quote unquote, to do that?
Sure. Generally, when someone's convicted and affirmed on appeal, it's very, very difficult to get any relief or that person vindicated. You can do it through a habeas corpus proceeding, but the fact alone that he or she is innocent is not enough to reverse the conviction. In 2019, the St. Louis City Prosecuting Attorney's Office filed a motion for a new trial for Lamar Johnson that we've talked about, claiming that they had evidence that he was innocent. The problem with filing a motion for a new trial under Missouri law as it existed then was it was out of time, which you have to file such a motion for a new trial within 30 days of any judgment. Now this years and years later. That went up to the Supreme Court. The Supreme Court affirmed the dismissal of the case, but one of the judges there said the way to resolve this is through legislation. So some of us, including myself, former Supreme Court Justice Mike Wolf, and the Innocence Project drafted a actual innocence statute. It's statute 547.031, which allows any prosecuting attorney in the state of Missouri who has clear and convincing evidence that the person may be innocent to file a motion to vacate the conviction. That statute became law at the end of August 2021, and there's been a number of convicted persons exonerated as a result of that, including Chris Dunn that we've talked about, including Lamar Johnson. But that only allows the prosecuting attorney to do it, not the convicted person, him or herself.
So let's talk a little bit about that law that passed in 2021 and how it changed how innocence works. So it allowed local prosecutors to hold hearings and to present evidence that someone was wrongly convicted. Kenya, why is it that this change was necessary?
Well, the change was extremely necessary because it gave an avenue. It created an avenue for people to be able to get back into court with their innocence claims. Those are still challenging because sometimes we have to rely on a gateway claim where there's some proof of there's a constitutional error. But one of the great and being able to get back into court for people like Lamar and Chris and Kevin Strickland and everyone who's been able to take advantage of that, that's been great. But what we still see a need for is for people to maybe not use that mechanism and be able to go straight to the court, because one thing we've learned is that there's areas in rural Missouri or smaller towns where they don't have the resources for the prosecutor's office to take on a claim of actual innocence, and so people are still kind of languishing. So I absolutely see that the legislation that Judge Wolf and Charlie Weiss worked on, it put a big crack in the ice, so to speak. There's just some room, I think, to pull that apart a little bit more to give people greater access to the court.
So the law is the thing that is at issue, not necessarily innocence per se. And there is a bill that's been introduced in this year's session of the Missouri legislation. That's HB 1075, and it would expand the scope of who can make an innocence claim. So, Kenya, what is it that this bill would do?
Well, this bill would allow people to directly petition their district courts and raise the claim. In Chris Dunn's case, I think 4 years prior to his being released, there was a judge who had said that he had reached the standard for clear and convincing evidence of innocence, but could not release Chris because he was not on death row. So having a vehicle like 1075, which I believe was paired with HB 731, would have allowed that particular judicial officer to be able to set aside, his conviction based on meeting the standard. And that is why I think this legislation is also a really important companion to the work that Judge Wolf and Charlie Weiss have already worked on. I think it gives that additional layer, which helps to support those areas that don't have the funds in order to be able to have a dedicated unit or a prosecutor's office that can file these particular types of motions.
Mm-hmm. Charlie, can you speak to why it is that this only has applied to cases involving the death penalty?
Yes. The Amrine decision, the case was decided by Judge Richard Titleman. A close friend of mine at the time is deceased. But it happened to be that Amrine was on death row when he was declared innocent. Prior to that time, just because you were innocent did not allow you to vacate your conviction. But Judge Titleman in the Amrine case decided that if you could prove by clear and convincing evidence that a person was actually innocent, that was sufficient to vacate the conviction. So what we need now, and so then what happened in the Kansas City Court of Appeals in 2016 in the Lincoln versus Cassidy case, there was a case beforehand that the person had been declared innocent and released. The Court of Appeals decided that the Amrine decision only applied to cases where someone was on death row, and they reversed the conviction. They reversed the decision, vindicating Mr. Cassidy. So what we have now is a bill pending in the legislature that not only the prior bill allowed only prosecutors to bring an actual innocence claim. Now under the current bill, any person who's in custody and who is actually innocent and can prove his or her innocent would be allowed to be exonerated, and that's critical.
Yeah. Do you have any? Oh, sure. Go ahead.
Charlie, correct me if I'm wrong. Is between the Amrine and the Lincoln v. Cassidy decisions, it created kind of a hierarchy. It said that because of the finality of being on death row, that there should be this allocation to be able to raise a claim of freestanding innocence. That was kind of the interpretation. So while it wanted to make sure that it was ensured that the death penalty was carried out with the utmost certainty of guilt, it also created what I perceive to be a barrier for those who are not on death row, but in essence are serving life without when they have 200 years or 150 years. So Charlie, that's my understanding.
I think that's correct. In the Rodney Lincoln case, Lincoln versus Cassidy, that's what made it, they clearly stated in that decision that the Amrine decision was only applicable to persons on death row. And since that time, in 2016, when that case was decided, the Supreme Court has not clarified the problem. That's the issue today.
So this new bill that has been introduced, it got a hearing last month in the Judiciary Committee. And Kenya, you testified in favor. And at that same committee hearing was Missouri Attorney General's office, represented by James Atkins. Atkins said that this proposal is a bad bill and that the office will, quote, will remain strenuously opposed.
I think this bill undermines the rule of law and is a miscarriage of justice, and if what's worse is it's doing it on the backs of victims. There's no mention in here about victims' rights.
So, Kenya, again, you were at this committee hearing. What's your impression of the points raised by the Attorney General's office?
Well, I think the greater miscarriage of justice is the fact that we have people who are sitting in prison for things that we didn't do. And while I clearly hear what he's saying about doing this on the back of victims, the way I perceive it is that we actually have two victims now. We have the victim of the original offense, but we've also created a second victim with someone who's sitting and doing time or is incarcerated for something that they didn't do. So I think that saying that we're creating this bill on the back of victims, I think is kind of ill-conceived. But that's my opinion. It's also, what they're very much hanging on to is Justice Scalia's idea behind judicial finality, and saying that once you have gone through the court system, you've exhausted your appeals, your post-conviction remedies, all of those things, once that they are exhausted, that they're finished. The case is done, even as it relates to actual innocence. Because Justice Scalia was not a fan of going back into these cases. Final was final. And I think that the office is actually is leaning with that principle. And I think that's the ideology from which they present. So I think that when we were talking about victims and it being a bad piece of legislation, I think that we have to acknowledge victimization at 2 points: people who are sitting in prison and the people who were victimized at the initial offense. So like in Chris Dunn's case, we had Rico Rogers. Well, now there's no one being held accountable for who killed Rico Rogers. The wrong person sat in prison for many years. So Chris was a victim there. And now we still have a family that's victimized because they truly don't have the closure on the murder of a 14-year-old kid.
Mm-hmm. I think this is a good place to pause. We need to take a quick break, but we'll be back shortly to continue this conversation. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Gemma, architects, planners, and designers seeking to bring joy to their clients and communities. Details at gemastl.com.
Welcome back. We're talking today about the way that innocence is recognized in Missouri law and how it is being used to exonerate people who were wrongfully convicted. I'm joined by St. Louis University professor and criminologist Kenya Brumfield-Young and attorney Charlie Weiss with Brine Cave Layton Paisner. Charlie has represented clients in 5 cases who were released after they were found to be wrongfully convicted. Now, before the break and earlier in the show, we checked in about the Missouri Supreme Court and the appeal by Missouri's Attorney General in the exoneration of Chris Dunn. Now, Kenya, obviously, this case will impact Dunn directly, but could this decision also change the 2021 law? And that's the one that gave prosecutors the power to review cases for wrongful convictions.
I think it will narrow the scope. It will impact how the law performs. So in Chris's case, one of the questions that was asked the 2 questions that were asked to the Supreme Court were, does the AG's office have the right to appeal? And second, where it relates to Chris, whether or not, if he does have the right to appeal, if it will be mooted because Chris is out. So I think that if there is the right for them to directly appeal per the Supreme Court, I think it may give some of the prosecutor's office pause as to whether or not they move forward, because again, that can be extremely costly, particularly for areas that don't have a lot of resources to engage in this type of litigation. Mm-hmm. So I think that it will severely diminish what the original law was intended to do. And so I think it will impact that law greatly. Mm-hmm. Charlie, thoughts?
Yeah, let me make one comment. As I say, we helped draft that statute. And we made it as clear as we could, I believe, that the Attorney General, him or herself, does not have the right to file an appeal which it claims is adverse. The provision in the statute states, the prosecuting attorney or circuit attorney shall have the authority and the right to file and maintain an appeal of the denial or disposal of such a motion. The Attorney General may file a motion to intervene. Intervene is important. And in addition to such motion, file a motion to dismiss the motion to vacate or set aside the judgment, and any appeal filed by the prosecuting or circuit attorney. So what this says is that if a circuit attorney loses his motion to declare somebody innocent, he or she can file a motion or an appeal with the Supreme Court, but the Attorney General himself or herself does not have the right to file the appeal. They can intervene in the state's appeal or the prosecuting attorney's appeal, but they don't have the right to appeal. So I don't know what the Supreme Court's going to do. I'm surprised they've heard it. But I would think that since decision after decision is when they interpret a statute is to apply the words as simply written. If they apply that principle, I think that they will deny the appeal by the Attorney General, and Chris Dunn will be free and clear.
Charlie, what is it about the Supreme Court's hearing this that surprises you?
As I said, when we start out, it doesn't surprise me because that's been their consistent position as long as I've worked with them. They have just unqualifiedly been opposed to anyone applying for innocence. It boggles. I mean, it's confusing and puzzling why they would do that, because we are all in a justice system. Justice should prevail here, and the common sense that someone is innocent should not be kept in prison once it's proven that he or she is innocent. There shouldn't be a debate on that.
The Attorney General's office has gone to the Supreme Court multiple times to oppose these sorts of cases. I mean, is that the intervention that we're talking about? What does this tell you?
It tells me that these cases are awful difficult, and the 5 cases that we've had where people have been exonerated, each one of them takes several years to proceed to a final judgment. And it's very difficult and very expensive, and most prisoners who have no money or are in prison can't afford to hire a lawyer to do that.
And that is something, Kenya, that you mentioned earlier, too. And I should note that St. Louis on the Air did reach out to the Office of the Missouri Attorney General, and we asked the office if it is seeking to put Chris Dunn in prison. We also asked if the office is trying to change how Missouri considers claims of innocence. We did not get a response to those questions. Now, Chris Dunn, as an exoneree, he faces the potential to return to prison. But then the way that these cases, the legal process, impacts exonerees and their families, Kenya, what kinds of insights can you share regarding that, especially given what you've said about multiple victims, not just one?
Well, what I think is, I can never, I would never be able to understand with, what Chris and like Sandra Hemme and all of these rules. The Hemme case has been settled, but Chris waking up every morning, trying to engage in a life that he's not had for over 30 years, reconnecting with family and, engaging with his wife and their family. And then every day having to wake up and wonder, is today the day that I receive the decision that they can appeal? Which, again, the statute is very clear. But should the Supreme Court say that there is room for the AG's office to appeal, I can't imagine what it's like for him to wake up every day with this still kind of hanging over his head. If it's not mooted by the fact that he's out, and if they could actually appeal him being free, what that even means for him. I think it actually re-victimizes someone who's already been victimized for over 30 years. I think it's insensitive at best, but I also think it's extremely, I think it's unfair. And I also think that according to the statute, it's being done where I think there's trying to be an appellate argument where none exists. And I think that the current legislation is very clear. So I can't even imagine what that's like for Chris every day to wake up and wonder, whether or not this is the day that his life again is turned upside down.
We had an opportunity to hear from Kira Dunn. In the past, she has been on our show, and she, as Chris Dunn's wife, has spent decades advocating for her husband's innocence. And she said that the uncertainty, especially at this point, is really hard to bear.
It's stunning. It's stunning that 2 prosecutors, 2 judges now have affirmed Chris's innocence, and yet here we are. Our legal team is optimistic, but really, as Chris said, this is Missouri. Anything can happen. And so that's another reason we've traveled and tried to do a lot of things together, because we're afraid. We're afraid that everything will be snatched away from us yet again.
But Kira does have hope, and this time she has her husband by her side.
It is different since he's here, and we have been able to live out many of those dreams and plans that we had, not by all means all of them, but some. At least now we're able to sustain each other. We're able to hold hands through this. We're able to, watch a movie together, just do average, mundane things that people do. Walk down the street, take a walk, to get our minds off it.
Charlie, do you think that there is hope for people like Kira and Chris? I mean, what do you think the chances are that this bill will change things?
Well, we're talking about the bill that's before the legislature. I hope it passes. There's always resistance. It's, as I said, it's puzzling why anyone would oppose a bill that someone who can prove their innocence can get out of jail. I don't understand it. I don't understand why they're in the justice system if they are. So I hope it passes, and if it doesn't pass this year, hopefully we can get it passed next year.
Charlie Weiss is an attorney with Bryan Cave Leighton Paisner, and Kenya Brumfield-Young is a professor and criminologist at St. Louis University. Kenya and Charlie, thank you so much for talking with us today.
Thank you.
This episode was produced by Danny Wissentowski.
Audio engineering and podcast design by Aaron Dorr.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations, and leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thank you.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.